Hello, Constitutional Law class, and welcome to Unit 4. In this unit, we continue our discussion of the commerce power through the present. In the last unit, I mentioned that we can identify three broad phases of Commerce Clause jurisprudence. First, a strong but still limited power prior to the New Deal. Second, a significant expansion during and after the New Deal. And third, a possible contraction as a result of the new federalism. As noted, this third phase is really our current historical moment, and it remains to be seen whether and how the court's changing makeup will influence any kind of new federalism. FDR's New Deal legislation did not fare well in the court at first. In RRB v. Alton Railroad, a 1935 case, the court held in a 5-4 vote that Congress cannot establish compulsory pension and retirement plans for railroads under the Interstate Commerce Act. Also in 1935, in Schechter Poultry Corp. v. U.S., called the Sick Chicken case, the court held federal wage and hour laws for local chicken slaughterhouse workers unconstitutional. And in the 1936 case of Carter v. Carter Coal Company, the court struck down regulations concerning working conditions in the bituminous coal industry. FDR was re-elected to the presidency in a landslide in 1936. Emboldened by this populist support, he responded to these court defeats with his infamous court packing plan, which would have allowed the president to appoint an additional justice for each sitting justice over the age of 70 who did not resign or retire, up to a maximum of 15 Supreme Court justices. Here is some of FDR's radio fireside chat on March 9, 1937, concerning the court packing plan.
I described in detail certain economic problems which everyone admits now face the nation. For the many messages which have come to me after that speech, and which it is physically impossible to answer individually, I take this means of saying thank you. Tonight, sitting at my desk in the White House, I make my first radio report to the people in my second term of office. I'm reminded of that evening in March 4 years ago when I made my first radio report to you. We were then in the midst of the great banking crisis. Soon after, with the authority of the Congress, we asked the nation to turn over all of its privately held gold, dollar for dollar, to the government of the United States. Today's recovery proves how right that policy was. But when almost 2 years later, it came before the Supreme Court, its constitutionality was upheld only by a 5-4 vote. The change of one vote would have thrown all the affairs of this great nation back into hopeless chaos. What is my proposal? It is simply this. Whenever a judge or justice of any federal court has reached the age of 70 and does not avail himself of the opportunity to retire on a pension, a new member shall be appointed by the president then in office with the approval, as required by the Constitution, of the Senate of the United States. That plan has two chief purposes. By bringing into the judicial system a steady and continuing stream of new and younger blood, I hope first to make the administration of all federal justice, from the bottom to the top, speedier and therefore less costly. Secondly, to bring to the decision of social and economic problems younger men who have had personal experience and contact with modern facts and circumstances under which average men have to live and work. This plan will save our national Constitution from hardening of the judicial arteries. Those opposing this plan have sought to arouse prejudice and fear by crying that I am seeking to pack the Supreme Court and that a baneful precedent will be established. What do they mean by the words, packing the Supreme Court? Let me answer this question with a bluntness that will end all honest misunderstanding of my purposes. If by that phrase, packing the court, it is charged that I wish to place on the bench spineless puppets who would disregard the law and would decide specific cases as I wished them to be decided, I make this answer, that no president fit for his office would appoint, and no Senate of honorable men fit for their office would confirm that kind of appointees to the Supreme Court. But if by that phrase the charge is made that I would appoint and the Senate would confirm justices worthy to sit beside present members of the court who understand modern conditions, that I will appoint justices who will not undertake to override the judgment of the Congress on legislative policy, that I will appoint justices who will act as justices and not as legislators, if the appointment of such justices can be called packing the court, then I say that I, and with me the vast majority of the American people, favor doing just that thing now.